Okay, welcome everyone to the Freeths and Gleeds webinar on disruption claims in Qatar. My name's Chris Soph and I'll be your moderator today. Just a bit about me. I spent 27 years as the CEO and president of Gleeds Americas, and I now serve on the as a non-executive director on the Gleeds Global Supervisory Board. I also oversee our dispute advisory services that are delivered from 74 offices around the world. I'm a past president of the Chartered Institute of Building, a fellow of the Royal Institution of Chartered Surveyors, a Chartered Institute of Arbitrators member, and a national panelist of the American Arbitration Association. So we'll crack on with the webinar. The webinar is to provide an overview of the disruption claims on construction projects in Qatar, and we'll be discussing issues faced by both owners and contractors. The pandemic and its effects have made disruption a very hot topic in 2020. Projects have been suspended and progress has often been significantly affected by alternative methods of working on site, along with external supply chain delays and labour productivity impacts. So the effects of the pandemic have often not been very well catered for in contracts, either in standard form of contracts or even bespoke agreements. The pandemic has often adversely affected supply chains and delivery dates, and ultimately overall project completion. It's also cost money, and frequently both parties have been financially impacted. Owners have been impacted because the project completion dates move further away, changing beneficial occupancy dates and often damaging contemplated revenue streams and increasing interest carries on construction loans. And contractors have been impacted because their work has taken longer and is often much less efficient, requiring additional resources, revised sequencing, or changed methods of working. Essentially, all of these are uncontemplated productivity effects. Typically, in considering the impacts of the pandemic, parties have had to consider whether the pandemic has caused impacts that fall within their contractual entitlements under three main areas. Those areas are force majeure, although force majeure claims typically represent an entitlement to extension of time and not money. So these impacts would be excusable, but not compensable. Second one is change in law, which may entitle parties to both time and money, but does not apply where the law is not changed. For example, if the government has implemented existing emergency powers. And finally, the owner's default. Some owners close their sites. If this was not the result of a change in law, this may have been an act of prevention or interference or obstruction, entitling the contractor to both extension of time and money. So if contractual entitlement is inadequately addressed, as may well have been the case in many contracts, then the parties must consider the prevailing law of the land and whether to settle by negotiation or battle out through an ADR process, or worst case, go through the courts. The impacts of the pandemic are project specific in each case, but the effects on construction projects have been similar all over the world. The Qatar market's no different, but the region has been particularly impacted by supply chain disruption, really because Qatar relies enormously on the import of construction materials, labor and equipment from South Asia, or perhaps China and the Far East, where the pandemic struck early. So some of these claims and effects are now quite mature. Parties are finding that although they're still committed to deliver projects, they're faced with the reality of those projects having to be delivered differently. So we at Gleeds and Freeths are beginning to see disruption claims resulting from the pandemic. These claims are often combined and sometimes are even confused with other issues. So we thought it's a really good time to revisit the core principles underpinning disruption claims from both legal and technical perspectives. So hence our series, Construction Disputes A to Z. This is our first webinar. We've come together with Gleeds. Gleeds has come together with Freeths to combine our forces so that we can offer a combined technical and legal advice and advocacy to our clients. if this webinar raises any issues on your projects where you think we can help, then please don't hesitate to get in touch with us. And that address is advisory@gleeds.qa. So with that, I'll move on to our experts today, who are Alex Johnson, a partner of the law firm Freeths, and Kamlesh Ruhan, who is a director of Gleeds in Qatar. And I'll let the guys introduce themselves. Alex, would you like to go first?
Yeah, hello everybody. Yeah, I'm a partner at the law firm Freeths. I specialize in construction and engineering law. I'm based in the UK, but my practice is international. So I've got experience of projects from all around the world, and in particular, I've worked on a number of construction disputes for projects based in Qatar.
Thank you, Alex. Kamlesh?
Thank you, Chris, and good afternoon, everybody. My name is Kamlesh Ruhan, and as the country director of Gleeds Qatar, I lead the service delivery in the country. I'm a chartered quantity surveyor by profession with 20 years experience, of which 8 years I've spent in Qatar. I've provided international cost management services on large-scale construction projects in the MENA region, where I have covered all aspects of quantity surveying and contract administration services. I'm also a member of the Chartered Institute of Arbitrators. Thank you.
Thank you, Kamlesh. A little bit about our questions policy. If you could submit any questions you might have arising from all of this to the Q&A box, and we'll allow time at the end to answer them as much as we can. If we can't get to them and you have any questions or issues you'd like to discuss after the webinar, again, please email them to advisory@gleeds.qa. So with that, we'll move on to the meat of the webinar. We'll go on to practical examples of the issues that the parties are facing to begin with. Alex and Kamlesh, what are the particular issues you're seeing clients facing in terms of disruption resulting from the pandemic? Alex.
Thanks, Chris. Yeah, I advised many clients at the onset of the pandemic, both in the UK and elsewhere around the world. And I think their questions were generally the same. What happens next? And who's responsible for the effects on the works? And the answers to those questions, depending on the particular situation, were not easy. We had a key difficulty, which is that contracts generally did not cater for the effects of the pandemic or any pandemic, and therefore parties wanted to understand their contractual position and their rights in terms of issues such as force majeure, changes in the law, and acts of prevention by the owner or the employer or contractor, depending on where they were in the chain. And an example that really stands out was a major construction project in the UK, where I was advising one of the key subcontractors. Now, the main contractor, following an announcement from our Prime Minister, which led to the first national lockdown in the UK, it immediately closed the site. So the Prime Minister was on television and he explained what would happen. And so in reaction to that, the contractor took this step. But the Prime Minister didn't go into the detail of whether construction sites had to close, for example. So when later the government confirmed that construction sites actually should stay open, as long as they could implement safe social distancing and safe working practices, then work could carry on as normal, or as close to normal as possible. So in this case, my subcontractor client considered that its works could continue, particularly as at that time, a lot of its work was being done off-site in manufacturing. But because the contractor had closed the site before the full government advice had been issued, then technically that was a breach of contract by the contractor. And so the closure of the site caused delay as well as disruption, because the on-site works had to stop, although they weren't very significant. But more key was the fact that the materials that were being manufactured and shipped to the UK had to be stored off-site, and there's a cost associated with that. So the subcontractor had a claim against the contractor for the storage costs and the other costs associated with that situation. And the basis of that claim was disruption. And that's a fairly typical and prominent example.
Thank you, Alex. I was going to say that's a common occurrence, I'm sure, in these times. Kamlesh, do you have an example?
Well, yeah, I do, Chris. Well, as with the rest of the world, the pandemic has certainly had an impact on the construction industry in Qatar. albeit with varying degree depending on the stage the project is at. And one of the common issue clients are faced with is disruption that the pandemic has caused to the supply chain in relation to the supply and availability of goods and materials, which most likely could have an adverse impact on productivity and by extension, delay to the completion of their projects. Again, a common question that clients and contractors alike are asking is who will bear the responsibility of the impacted work progress? And the answer is not straightforward, as it would depend on the specific contractual terms and impact the pandemic had specifically had on the project. One of the difficulties faced by contractors, for instance, would be to firstly prove the cause of the disruption and its impact on productivity, and secondly, valuing the alleged loss in productivity. Whilst contractors, generally speaking, would want to ensure that they are compensated for damages done as a result of disruption, the major challenge here would be to properly demonstrate cause and effect of the disruption and loss of productivity, as in a lot of instances, the loss is attributable to other events and project stakeholders. Thank you.
Thank you, Kamlesh. So moving on to the prime topic, Alex, could you explain to us what is disruption?
That's a good question, and I suppose an important one given the subject of today's webinar. I'm going to begin with a couple of definitions that I will share. So Keating on construction contracts, which is one of the Bibles that construction lawyers will follow. It's a key textbook. Says the disruption is a disturbance of the contractor's regular and economic progress and or delay to a non-critical activity, even though on occasion there's no or only a small ultimate delay in completion. And the Society of Construction Law Delay and Disruption Protocol, which I'm sure people are familiar with, describes disruption as a disturbance, hindrance, or interruption to a contractual's normal working methods, resulting in lower efficiency. Disruption claims relate to loss of productivity in the execution of particular activities. Because of the disruption, the work activities are not able to be carried out as efficiently or reasonably planned or as possible. So there's quite a lot going on in those definitions, but to boil it down, I think a good way to think about disruption is to consider two key points that arise from both of those definitions. And the first is that there can be disruption without delay. And the second is that disruption comes from lost productivity or lower efficiency. And as such, it has a financial impact on the project. So a good way of thinking about disruption is to consider it in terms of money, not time. I think disruption is sometimes thought of as the financial side of a delay claim, and that's a misconception. Time and money claims are separate, and they must be claimed separately. So in sophisticated construction and engineering contracts, a claim for an extension of time is one that relieves the contractor from liability to pay liquidated damages for delay, and it results in a revised completion date. A claim for additional money, however, for example, prolongation costs is a key disruption aspect, is a separate claim, even if the circumstances that give rise to the event are the same in both cases. So prolongation costs are not the financial losses that flow from an award of an extension of time. And again, I think sometimes that's a misconception. So it's very useful and very important to delineate time and money when we talk about disruption. I have to say here that it's hard to talk about disruption in construction projects without talking about how disruption claims have a reputation for being difficult, complex, and expensive. Three words that clients love to hear in my experience. Fundamentally, though, I think, like any claims, a disruption claim needs to show two simple things, and that's cause and effect. The difficulty with disruption claims is usually proving the cause. The effect is quite easy to identify. You may identify it later than you thought, but you will identify it. So I'll say something about burden of proof. So under English law, the burden of proof in civil claims is known as the balance of probabilities. It's sometimes described as the 51% rule. So a claimant must prove that it was more likely than not that disruption occurred, for example. So against that burden of proof, disruption claims will require the claimant to prove three things in principle. Firstly, that the events happened which entitle the contractor to compensation, or subcontractor as it may be, or that caused the employer to breach the contract. Second, that those events cause disruption and or delay. And thirdly, that the disruption caused the contractor to incur additional costs or damages. Now, proving that an event or a multitude of events occurred in retrospect can be very difficult. It's often difficult to tell at the time that disruption is actually occurring. I think typically disruption only reveals itself later on when the impacts can be seen. I think it's also worth mentioning that contractors don't have an automatic right to claim for disruption. They've got to establish one of two things: either that there's an entitlement to additional payment that exists under the contract. So, for example, the 99 FIDIC Silver Book, clause 8.9, for example, says that the contractor is entitled to an extension of time and cost from complying with the employer's instructions to suspend the works. And work suspensions were things we saw a lot in the pandemic to begin with. Or the other thing that has to be shown is that the employer breached the contract and therefore the contractor is entitled to claim damages. And just to give some context there, in terms of disruption claims, it's important to bear in mind that there's a distinction between a claim which is made under the contract and a claim which is made for breach of the contract. So a breach of contract claim is one that results in damages, where the recovery is compensation, and it's subject to any limitations or exclusions of liability that there may be in the contract. Whereas a claim that's made under the contract is different. Now, most construction engineering contracts will give the contractor rights to claim additional payment in certain circumstances, which may themselves be a breach of contract, for example, an act of prevention by the employer. But those are rights that exist in addition to damages for breach of contract. So that's my long answer to what is disruption, Chris.
Thank you. So they're difficult and they're complex.
Yeah.
So, Kamlesh, what are the difficulties you see in terms of assessing the value of these disruption claims?
Well, disruption or loss of productivity is often difficult to track and assess, as opposed to direct cost impacts, which can be fairly easy to document and quantify. When we consider isolated changes, for instance, the direct impact can be individually measured and quantified insofar as one could calculate the difference between the reasonable cost for carrying out a particular activity under normal condition versus the reasonable cost to perform the work as changed. However, it is quite challenging when disruption impact is cumulative due to the secondary knock-on effect that a change may bring about to other unchanged works, for instance. To be able to split this is quite a tricky task in itself. There's also perceived difficulty in segregating concurrent contributing factors, such as adverse labor market, mismanagement, or inadequate resourcing. Assessing the impact of disruption to put a contractor back to the position it would have been had disruption not occurred is quite a challenging analytical task. In addition, without a clear methodology, when assessing the change in productivity, the assessment would be quite difficult. Very often, we have come across claims that are dealt with in a retrospective manner, where you'll find that the claimant would rely on poor, inaccurate, and non-contemporaneous records in an attempt to establish cause and effect. So, in order to conduct a meaningful analysis and an assessment, the issues that impacted on productivity should be isolated and the cause and effect clearly identified in the first instance. And also, all concurrent factors should be separated and there should be an auditable methodology in place. What we need to bear in mind here, Chris, is that a contractor's ability to recover cost overrun for a disruption claim would largely depend on its ability to prove the causal connection between the impacting condition and the resultant loss.
Thank you, Kamlesh. It's most helpful. So what losses are typically claimed? Alex, could you answer that one?
Yeah.
Specifically related to disruption claims, of course.
Yeah, sure. Thanks, Chris. There are typical heads of loss in any disruption claim, I think. So I'll explain the main heads of loss, which we typically see. So I suppose the first big pot of money that usually parties are interested in claiming or avoiding a claim in relation to a prolongation costs. Now, essentially, those are the on-site and head office overheads that are caused by delay or disruption. Prolongation costs are the unavoidable costs associated with an extension of the contract period, even where the amount of work being carried out has not changed, so a disruptive effect. And ordinarily, those costs will take the form of on-site overheads. So those are time-dependent costs that are not part of the finished works. So the costs of labour, cost of utilities, the cost of plant, being on the site longer than the contractor originally planned. And also there's offsite overheads, so sometimes also known as head office overheads, which are the cost to the contractor of running its business. You can see how both of those things can be increased if the contractor is on site for longer, or plant and materials and labour are in places where they shouldn't be as a result of disruption. Now, overhead claims tend to be made in one of two ways, either by showing evidence that the actual overheads were incurred, or generally by a percentage uplift, which is applied to the increased cost of the project. I mean, the better approach is to provide the evidence that the overheads were incurred. I think in construction cases, which are known to be complex, tribunals are likely to reject a claim for overheads based on a simple percentage uplift only. And so in my experience of arbitration, it's preferable to, as far as possible, fully particularize any actual overheads incurred by reference to evidence. Because if you don't, then the risk is that the court or the tribunal may draw an adverse inference from that. So in essence, they may say, well, we're presuming that the claimant can't prove its position because all it's doing is applying a percentage. So it's important to bear in mind there the mantra that he who alleges must prove. Finance charges are recoverable. If the contractor borrowed money to finance the project and is delayed or disrupted, then finance charges may be recoverable. Loss of profits is another key element. It's usually tied in with a claim for overheads, and again, it's commonly done on a percentage basis. But again, I sound a note of caution. I think whether that is sufficient to meet the burden of proof depends on the circumstances of the claim. And so for a large company, I think with many projects ongoing at any one time, then a percentage is probably sufficient as long as it can be supported by accounts. I think for smaller companies, then evidence is probably needed. So evidence that shows the tender opportunities that were lost during the period of disruption, for example. A few other heads: general disruption. The cost of general disruption, that's where the contractor incurs costs as a result of the inefficient use of plant or labour, or where the plant and labour differs from the intended use. So this can arise even where the project isn't delayed. But the difficulty is proving that it results from change orders or employers' breaches of contract, rather than things that the contractor was responsible for in any event. So if its working practices were just inefficient, or if the contractor low bid the tender to begin with. You've also got wasted management time, which is similar to the other things I've mentioned. This is the cost of employees or senior managers dealing with projects for substantially longer than they originally planned to in the tender. The costs of that can be claimed as long as they're not also claimed separately as overheads. So this is a point to note in disruption claims, that parties have to be careful of potentially double dipping in making disruption claims. That's to say, claiming essentially the same money under different heads of loss. It will quickly get struck out. Wasted management time claims also need to show the extent to which staff have been diverted from their roles, and that the diversion caused disruption to the contractor's business. So to establish that, it might be necessary to produce timesheets, for example. And then a couple of other things. Legal fees. Legal fees are subject to cost awards, and they cannot be claimed as damages, but typically costs recovery in arbitration is around 60 to 70% for the winning party. So winner usually pays the loser's costs. And expert fees, those can be claimed as damages. So those are the main losses.
Thank you, Alex. Interesting indeed, especially the wasted, inefficient management time, disruption on management. It's interesting.
Hmm.
Kamlesh, what records are you looking at for evidence when assessing the value of the construction claims in the categories we just mentioned above?
That is a good question, Chris. Generally, what would require are typical contemporaneous records, which in the main, we would be looking for daily report, which is of paramount importance. And they should identify, for instance, the tasks that were carried out, showing a record of progress for the task or activities, and also list of event or events that hindered progress or caused disruption. Um, it should also include labor and equipment allocation sheets showing the during the normal working sequence without disruption, and also a revised allocation sheet following disruption. These would be mainly for the measured miles analysis to help in valuing the disruption or loss in productivity. Um, Also, site instruction and site evidence by way of progress photos. You could have photos showing the before and after an event had occurred, where, for instance, a method of working was impacted, or indeed access was hindered. Um, in addition, yeah, contemporaneous emails, letters, minutes of meetings can also help. But what would like to stress here is that the quality of the record is very important. Um, in the case of a disruption claim, for instance, that relates to COVID-19, it is advisable that the daily report make specific reference to it, like list the specific impact to work activity. And as an example, the contractor may have had to carry out additional screening of labor coming on site, might be doing temperature checks, etc. And that could impact on the daily mobilization. There's also alteration to ingress and egress points to your workplace due to restrictions and social distancing, which may impact on the sequencing and method of working, or indeed impact on a particular work area that could be a hindrance that slows an activity. Um, so we do appreciate that complex construction sites may render daily record keeping difficult, but at least it is strongly advised that contemporaneous records are kept for known impediment in as much detail as possible in support of any future claims. So that would be very helpful. So in brief, what we'd like to say is that daily reports would act as a refresher further down the line on the activities that were carried out, and so to speak, would provide a picture of what actually happened on site at a particular point in time where progress may have been hindered. So documentary evidence by way of daily report is very important.
Thank you very much, Kamlesh. So, as ever, robust reporting and daily record system so important in this. So, Alex, what does a successful disruption claim look like in legal terms, and how are they successfully made or defended?
Thanks, Chris. Well, I think ultimately a successful disruption claim is, from the client's point of view, one that leads to the recovery of money in the event that they have to make that claim. So I think as I explain what makes a successful disruption claim, it should be kept in mind that the adverse is what makes a claim attackable and potentially less successful. So, what's good for a claimant is also bad for a defendant and vice versa. So I'll highlight the type of points that the defendant may be seeking to make when it's trying to undermine the claimant's claim and successfully defend the claim. So a bit of background, I think. My experience of construction projects in Qatar is that claims are not uncommon. And I think they're generally even almost considered part of the deal. So I think there's an expectation by commercial parties that claims are probably going to be made. And I think some of that comes from how the projects are bid in the first place. So my view on it is that I think disruption and other claims are sometimes almost baked into the project at the bid stage, because if the lowest bid wins, then that clearly leads to competition from the bidding contractors. And so it also sets the expectation that profit is probably going to be earned through claims. And I think contractors know that, certainly, and owners are probably aware of it too. So disruption claims, I think if they're successful, they can be particularly lucrative, all of which means that parties have to be ready to make and defend claims, in the Qatar market and others as well. And contractors need to be able to produce good claims that secure entitlements, and conversely, owners need to be in a position and prepared to defend those claims. So the best disruption claim in legal terms would be one where each event which is being complained of is fully particularized, and the disruption that is said to be consequent on those events is evidenced through comprehensive and detailed contemporaneous records. Now, how often does that happen? Practically never. So you're always looking at alternatives. And as I said, disruption claims are difficult and complex. And it's the amount, the type, and the quality of evidence that's needed to fully particularize a claim that makes them difficult. So if it's correct that full particularization and fully evidencing a disruption claim is just inherently difficult, what are the options? Well, typically the amount and the quality of evidence that's on offer will dictate the approach that is taken to pursuing the disruption claim. So generally, the less evidence-based the method and the more theoretical the method is to establish the disruption, I think the lower its chances of overall success. So at the extreme end of this, the theoretical disruption claim is the total cost claim. And closely behind that, you have the global claim. Now, these are types of claim where little or no attempt is made to prove causation. And the principle is really, well, A minus B must equal C. So in essence, in a total cost claim, the contractor is claiming its additional costs above tender costs on the basis that that was caused by employer-driven events. But the contractor doesn't demonstrate any causal link between the events and the costs that were incurred. So typically, parties would be best avoiding making those types of claims, particularly where there's a possibility that the case may end up in arbitration. At that stage, things can quite quickly unravel. I do accept, though, that those claims have some utility if the intention is to prompt commercial discussions, for example, if that's part of a wider strategy, or to seek an amicable settlement. I think the danger is they can be quite simply undermined if the other party's got really good factual evidence. So if a party can show with evidence what actually happened, then the claims can be defeated. If a claim is made by a contractor based on an assertion, but the factual records show that to be absolutely false, you can see the problem of this type of claim. So somewhere in between the perfect claim and the theoretical claim are the productivity-based methods that we all use, such as the measured mile. So the measured mile is well known, and it's a method of measuring disruption based on an analysis of productivity levels for an activity or a time period when there was no disruption. So that forms a baseline against which to monitor any disruption, which allows for the difference that is expended in resources to be quantified. But I think a problem with it is that finding a mile to measure in a complex engineering construction project can be very difficult, particularly if the records haven't been kept or not properly kept. So if disruption is severe, there could be no undisputed measured mile to compare things to anyway. And if the works are complex, then there may be no standard section of works or too many measured miles to make any one particular measured mile or multiple measured miles practicable. So there are those issues that have to be considered. And again, the evidence that's available will drive that approach. And a couple of other points. A lot of claims fail because parties just forget the basic stuff. Making a disruption claim or making any claim under a contract requires the party usually to comply with certain steps. So, for example, giving claim notices within a certain period of becoming aware of the claim. Now, that's a condition precedent under most contracts. It certainly is under FIDIC terms. And failure to comply with those conditions precedent can simply mean that entitlements to claim are lost or waived on a basic technical point. So I think sometimes there's a feeling, perhaps by contractors, that we shouldn't be putting in claims notices because we don't want to upset the owner, particularly early on in a project. Whereas in fact, contractors shouldn't be so shy. Just follow the contract. If the contract requires a claim notice, make a claims notice, because this can avoid those claims just being taken off the table on a technicality point. I think finally, it's important to mention quantum. A disruption claim should have a realistic quantum assessment. And again, it must be evidence-based. So it's common for parties, I think, to overinflate claims or to include, let's say, questionable claims alongside otherwise good claims. Now, that's best avoided. In my experience, it's got quite a high failure rate. And I think when you include bad claims with good, then the bad risks tainting the good. So you can otherwise lower the credibility of a good claim by including a load of bad claims along with it. And I think it's better to have a claim that might be lower in value, but where every real can be proven, than it is to have a claim that's higher value but is mostly a work of fiction. So I think in summary, a successful disruption claim is realistic, it's evidence-based, and it's credible. And what do you need to achieve that? Simply, as Kamlesh has already said, it's about the records. So the importance of keeping clear, comprehensive, and detailed records shouldn't be underestimated. Good records with work can be converted into money. Non-existent records cannot be converted into money. So you're always better keeping some kind of a record. And a lot of claims fail simply because they're poorly formulated, because they're unrealistic, but most importantly, because they're not grounded in the facts of what actually occurred. And that's what can really undo a claim. The more theoretical the claim, the easier it is to defend. The more realistic the claim, the better it is, but also the harder it is to defend.
Thank you, Alex. That's sound advice. So, Kamlesh, what are the common issues you see with the claim documents, and why do claims fail from your perspective?
Thank you, Chris. Well, very often what we find is that the basic requirements have not been properly considered by the claimant. Here, what we're trying to refer to is the acronym CEES, which boils down to cause, effect, entitlement, and substantiation that have not been properly addressed. So, for a claim to succeed, it must be properly demonstrated, substantiated, and justified. Um, in a lot of occasions, the documentation is poorly put together. What we found is we found out that the claims were not presented in a clear and logical manner. So there was no way you could follow what was being claimed. Now, if you imagine the reviewer having to go through a claim that is not clear and logical, that will put him or her straight off straight away, and one's claim will more likely to fail the credibility test. As Alex said earlier, there's also a tendency to mix good and bad claims, which we've seen very often. So the advice is to try and avoid mixing the good and the bad claims together to stand a better chance of success or winning something at least. We have also come across a number of claims that are very often generic global claims with very little or no substantiation at all. Again, there is a lack of contemporaneous records to support an event, for instance, that could give rise to a claim. What we've also found out is there is also a lack of contractual basis. What we need to bear in mind here is the failure to prove contractual entitlement may cause the claim to fall apart. Bringing about a disruption claim or any other claim indeed requires clear demonstration of entitlement. It is very, very important in the first instance because a demonstration of cause and effect simply would not give rise to an automatic entitlement. That is something that we need to bear in mind. And also, very often again, costs are spurious amounts and the calculations are unrealistic. In my experience, I have come across contractors who made generic notional claims with the hope of reaching a settlement on a proportion of what's been claimed. But if the claimed amount is spurious and without any basis whatsoever, it is less likely that some sort of settlement would be reached, to be honest. So the advice here would be to ensure that the claim is properly justified and substantiated to stand a good chance of success. And to say, therefore, the key aspect that we'd like to highlight here again is records. This is what we call the magic word. It will definitely help in if the documentary evidences are provided in support of a claim. Thank you.
Thank you, Kamlesh, and some common themes evolving. So to summarise, we've told you about Gleeds and Freeth joining forces and why we've taken this important step. We've given you some practical examples of issues that the parties are facing. Alex has defined disruption in legal terms, and Kamlesh has explained the difficulties in valuing disruption claims. We've described which losses are typically claimed and what's needed to successfully make or successfully defend construction claims. We hope you've enjoyed hearing from these experts. We're just going to have a quick last summing up from them. We hope this insight has been helpful to you. So Alex and Kamlesh, do you have any advice for parties in relation to contract drafting and to summarise all this?
Yeah, thanks, Chris. Before we go into contract drafting, I just want to reiterate that point that Cam raised right at the end, which is, records. That's the key takeaway from today. As you're on your project, and we appreciate that construction projects are complex, difficult, etc., but creating the records and keeping them in order to explain the facts of what happened on the project is really critical. And as close as the parties can get to a real-time account of the project, the better they can make good claims, and the better position they're in to defend bad claims when they're made. As to contract drafting, and in terms of the pandemic and further disruption, I think parties are well advised to make provision now for what happens as a result of the pandemic as it goes forward in a contract, particularly from a contractor's point of view. We've seen how the pandemic has caused suspension of the works, how it's caused changes in how works are carried out. And I think it's left a situation where it's quite unpredictable, the extent to which the pandemic may place a further impact on construction projects. I think an important point to note is that the pandemic is no longer force majeure, because force majeure events are unforeseen events that parties can't provide for at the time of entering into a contract. I mean, the pandemic has been going for almost a year in most areas of the world, and it's no longer unforeseen or unknown about. So parties really have to ensure that contracts that they enter into today specifically deal with the time and the cost risk of further impacts to the project that could be caused by the pandemic. So contractors, I think, should be particularly careful, because if the contract doesn't specifically deal with pandemic, then it's likely that it will simply be a contractor's risk on the basis that force majeure is unlikely to apply. I think, first time around, a lot of parties agreed to compensate contractors in terms of time, but not always in terms of money. And so I think it remains to be seen whether this continues to be viable for contractors, given the ongoing situation. And in countries that are seeing multiple waves of infection and corresponding lockdown measures and restrictions. And I think finally, the one, I suppose, silver lining that I saw last year was that the pandemic situation really showed a case for a more collaborative approach between the parties towards dealing with project risks. And a lot of parties were prepared to put the contract to one side, to have a discussion on a commercial level and come to an alternative arrangement, rather than have a dispute over effectively a force majeure event. I think arbitral tribunals will be quite unimpressed by parties seeking to claim money from the other due to a force majeure, if that's permitted under the contract, which of course it usually isn't. So I think a more collaborative approach, if that comes out of this situation, then I think that's to be welcomed.
Thank you, Alex. Kamlesh, would you like to summarise and address contract drafting at the same time?
Yeah, certainly. What I'd add is making provisions with respect to COVID-19 in the contract will certainly ensure that there is a clear mechanism to deal with the impact of the pandemic on construction projects. It would be advisable to have provisions to deal with the relief when it comes to time and money, but most importantly, provisions that clearly identify risks allocation. However, it is very important to bear in mind that any claims arising of the impact of COVID-19, in particular disruption claims, will still have to be properly demonstrated with full supporting particulars. There's no way around it. So for a claim to be credible, with a better chance of success, contractors in particular should ensure that their claims are well structured, clear, logical, and fully supported. And as we've said earlier, all we need to do is just follow the basic requirements that are identifying the cost, effects, entitlement, and substantiation. So just to close off as a final reminder, it is strongly advised that contemporaneous records, by way of daily report, for instance, that clearly identify the impediments, are kept to support any future claim. So that is something to bear in mind. It's very, very important. I know we've kind of mentioned it many times during this presentation, but it is very important with respect to supporting any claims whatsoever. Thank you.
Thank you, Kamlesh. And a little bit from me, I wholly support Alex's statement there. Humanity's been plunged into the pandemic, so the more we can all look for solutions and have good behaviour, be proactive, collaborative and conciliatory, we can have empathy for the other party's positions. We're going to solve claims. And I would say always remember that a good settlement is one in which neither party is happy. So always driving away to that. So we've got about 10 to 15 minutes now for a few questions. So let me see here if I've got some come up here. Here's a question. Can the contractor consider the governmental instruction for complete closing as a force majeure? And can a contractor consider time and cost claim to be combined with force majeure and disruption? So who would like to take that one?
Yeah, I'll take that to begin with. I think this question sort of goes to the heart of, what does the contract say? And let's assume this is a fairly typical contract situation. It sort of harks back to the debate that I was hearing a lot of last year, which is, well, what event does this situation sit in, really? And to begin with, it was a lot of discussion around force majeure, because it was, a pandemic was clearly the sort of thing that neither party could provide for or allow for. But the problem for contractors was that force majeure is usually a time-only event. It doesn't automatically give rise to additional payment. So I think from the contractor's point of view, they were looking for other things. And so in some cases, we were seeing change in law arguments being made, because depending on what governments did, there may have been a change in the law. So a government implementing new legislation is a clear change in the law. But in contrast to that, some governments just exercised existing emergency powers. And so that wasn't a change in law. And then I think the other thing was really analysing the owner's behaviour. And a lot of owners, I think, quite rightly thought to be proactive, like the one in my example did, and just thought it would be prudent to close all the sites. But the problem with that is, if you do that without some proper legal and technical advice, then you expose yourself to a breach of contract claim. So I think, in summary, this was all quite difficult. And I think establishing clear rights to additional payment is fraught with difficulty, but it hinges on what the owner did, really. That's the main source of, I think, additional payment options for the contractor.
Thank you, Alex. Here's one for Kamlesh. How can we substantiate and show head office overheads in prolongation costs? I know there are formulae that help with that sometimes as well.
Yeah, certainly. Good question. Well, if I can say, in my experience, from what I've seen, very rarely I've seen a contractor using formula to calculate head office overheads. In a lot of instances, I would say all they do is just apply notional percentages that have been applied to value of works without any justification or evidence whatsoever. So how do we calculate it? So what would advise is, for instance, if this contractor claiming for it, the contractor demonstrate with evidence through records that the overhead was actually incurred. And in the event that this is not possible, then perhaps use the formula to assist in quantifying any loss of overhead. But however, we need to bear in mind that the burden of proof rests with the claimant. We would advise, or it's advisable that that proper record or use and proper demonstration of the cost incurred is followed.
Thank you, Kamlesh. And I think there's one here for Alex. Alex, considering that most of the forms of contract have a common law background, are there any local civil code provisions that can override the contract provisions with regard to contractor entitlement for extensions of time or relevant events?
Yes, is the basic answer. I'm a common law lawyer. I'm qualified in English law, so I'm not qualified in any civil jurisdiction. But having had experience of projects in Qatar, I know that there are provisions of the Qatar Civil Code, for example, that are potentially very helpful to contractors. And I'll cite a couple of examples. One is, I think, there's an ability to challenge liquidated damages, which you don't have under English law. Under English law, liquidated damages are inviolable and they're agreed and they are what they are and they will be paid. Whereas I think through the Qatar Civil Code, those can be challenged as to whether they're appropriate. And another point I think is that there are elements of the Civil Code, such as gross mistake, for example, which can unravel agreed caps on liability and exclusions on liability. So, highlighting those things, I'm saying, I'm sure if you have a civil code that applies to your contract, it is very worth checking that out, because unlike common law, the contract is not the be all and end all. The civil codes have to be explored, and the options under the civil codes very much have to be considered as part of the response.
Thank you, Alex. There's one for Kamlesh here. Here's one I think might be obvious, but if timesheets are not available, what other records could be used for wasted management time?
Quite interesting one, actually. Well, as we've said earlier, it is very important. It's very important to record any time spent on a project or any wasted management time. In all instances, there ought to be some sort of timesheet. Whilst you're saying that timesheet is not available, there ought to be some sort of method of recording any management time being spent on a project where disruption may have occurred. So it is quite important that regardless of whether there's a timesheet, there is a way of recording any time, any wasted management time being spent on a project that's been disrupted.
Thank you, Kamlesh. And a related question here: does a disruption claim entitle the contractor to claim for its direct cost, and as an example, the salaries of idle labour?
Well, the answer to that would be it all boils down to, first of all, again, going back to the basic of proving the cause and effect, entitlement, and substantiation. If there has been idle labour, what the contractor will need to prove is whether the idle labour was as a result of the disruption. So what the contractor will have to do in the first instance is to show the level of the labour level that they had at the start or during a normal period where there was no disruption whatsoever, and thereafter how the labour was impacted, whether there's been restriction or for instance, due to social distancing, some of the labour couldn't work in a confined space, therefore some of the labour became idle. Or it could be that the labour became idle because there was a disruption in the supply chain by way of having the material at the right time. But to sum up, what is very important here is it can be claimed provided all the supporting evidence have been provided to prove that the labour was idle as a result of disruption. It could be that there's been a mismanagement, or the labour was, or the planning itself, the planning of the labour to the particular work phase was not done properly in the first instance. So the contractor could be trying to say that yes, the labour was idle because of a disruption due to COVID-19, for instance. But again, it all needs to be proven that it was as a result of the disruption.
You have to link it. Yeah.
Exactly.
Yeah. Here's one here. It's a bit legal. Alex, see if you can try this one. Has the panel seen any reference to Article 171 of the Civil Code for exceptional circumstances rather than force majeure? And do you have any advice on how to deal with this?
No is the answer. Not specifically, but then that doesn't mean that it hasn't been on the table. As I said, I'm not a civil code qualified lawyer, but and so I tend to look at arbitration and English law that applies to contracts. But I would think probably taking some local law advice on that point would be the best answer.
Mm-hmm. Okay, thank you for that. Another legal one, Alex. COVID-19 impacts can be, in caps, adjustment for changes in legislation as per subclause 13.7 under FIDIC 1999. Have you come across that one? Adjustments for changes.
Yeah, that's what the clause is described as, isn't it? I think adjustments for changes in legislation, I think it says. I think when changing law is under discussion, you need to really look at what the specific clause says and also what specifically happened. I think in the UK, we were quite clearly implementing new legislation to deal with COVID. So there were COVID regulations, for example, that were brought into law quite quickly. And to the extent they impose on contracting parties in construction projects the need to change the way that they do things, I consider that was probably a change in law in general contract terms rather than anything specific. I think the difficulty comes in other jurisdictions potentially where the government could just decree something that could be a change in the law, but it might not be a change in the law. And I think the really difficult category is where the government implements powers that it already had in the event of an emergency, which may well substantially change how things are done, but is not a change in the law because nothing new has changed. It's just doing what it always had the power to do, but had never done up until this point. So I think my advice on any kind of change in law issue is to look carefully at what happened. Did anything change? And then analyze that against the relevant clause in the contract.
And here's, thank you, Alex. There's a broader one here, which is interesting. Is there any conflict that could occur between a disruption claim and a constructive acceleration claim? And if both are occurring, what are the implications of both happening on the same project?
I think the answer is I can't see in principle why you might not have both arguments. And I think whenever you look at these kind of issues of what event caused the delay, that's what you're ultimately trying to find out, which event caused a delay. And obviously it's never the case that there's just one event on a construction project. There's always more than one event, or more than one opinion on events, etc. So it's dealing with the concurrency of events, which I think is quite important. And obviously the concurrency could affect something like constructive acceleration as compared to disruption. But the position on concurrency in terms of money is not as clear cut as it is in terms of time, at least under English law. The courts have been quite clear about what happens in terms of concurrent delay where it affects time, but concurrency of disruptive events or other events is a thought-provoking issue. And I think my initial reaction would be, well, what caused what, I think would be the starting point. What caused the money to be lost or whatever it happened to be, and would that have happened but for the other event? I think that's probably the basic test, but there'd be a lot of analysis into what specifically had happened.
That rolls into another question, a quick one just to finish with here. We're running short of time. Kamlesh, how do I show the disruption was COVID and not something else, which is a similar question?
Again, it's pretty much similar to what we've answered earlier, insofar as the contractor will have to demonstrate that prior to COVID kicking in, during a normal working time for a particular workplace, for instance, compared to when COVID kicked in, there was a disruption caused to labour or productivity for work that was being carried out. So what contractor sometimes would try to do is try and put everything in one basket to put it against a COVID claim. So it's quite an important question insofar as, yes, it all boils down to the contractor segregating any cost, any effect that the disruption may have happened as a result of COVID-19. So in essence, what the contractor ought to do is to prove that the disruption happened as a result of COVID-19. For instance, as I said earlier, it could be that the ingress and egress to a particular workplace was changed as a result of social distancing, or to maintain minimum people or the maximum people on site to avoid contamination, for instance. So in essence, the contractor will have to prove that any impact caused or any disruption that happened was as a result of COVID having kicked in.
Okay, Kamlesh, very good. So we're right on the hour mark now. In closing, if anything that we've discussed today raises any questions or concerns on your projects, please email us at advisory@gleeds.qa, or simply contact Alex or Kamlesh directly. And thank you to the panelists here. Terrific insight into this difficult topic. If you've enjoyed this webinar, it's the first of a series offered from Gleeds and Freeths. If you have some claims and dispute topics that you'd like us to address, then send them over and we'll do our best to help. So with that, wish you well, thank you, and enjoy.